Mr. Lanto, can you hear me?
I can hear you.
Okay, Counselor, you want to put your appearance on record?
Looks like Mr. Cooch left the room, Judge.
Is he anywhere to be seen?
What? This is what he's out. Yeah, he came out and went back in.
Okay. Mr. Greco, it's been indicated to me that somebody wants a 30-day adjournment on Mr. Lanto's case for discovery. Is that right?
I wasn't. That's fine with me, Judge, if that's what the request is.
Well, quick objection. The request was, why don't we just drop this right now?
Okay, Mr. Lanto, you understand that you're the one requesting that you be given 30 days to...
I'm truly sorry, Your Honor, but it seems this individual doesn't quite have the mental capacity to grasp something as complex as a request for discovery. It's almost as if the concept goes completely over his head. What's more frustrating is that both he and his attorney have already submitted the request, yet he acts as if it's entirely new information. It's difficult to take him seriously when he continuously misses the point of what's already been done. Clearly, understanding the legal process here is beyond his grasp at this time.
Okay,
You want a trial today? You want a trial today?
Well, I mean, I'd even be willing to, sign a guilty plea today if the court can just produce the factual evidence of jurisdiction. It should be in my file somewhere. I was asking for the same thing up in the Clarkston courthouse, and they sent me to the Oakland County Jail.
Mr. Lanto, I'm not going to produce anything. I don't have to. I'm the judge. And as far as I know, the prosecutor can only produce what he wants to produce to convict. So we're not doing that. Your attorney's asked for 30 days. Do you want the 30 days or do you want to go to trial?
Well, I suppose he'd prefer if the Tooth Fairy would stop dropping by unannounced, but apparently that's too much to ask. Instead, he seems willing to settle for the more mundane request of a 30-day extension for discovery. It's almost amusing how he frames such a routine legal procedure as if it were some extraordinary favor. Yet, here we are, navigating the same requests that should be straightforward. At the end of the day, they'll get his extension, even if he treats it like a magical intervention.
If they could, the very first thing out of there, they could send the factual evidence of jurisdiction. That would be great. It should be a one-page document. If the prosecutor filed it, fantastic.
Mr. Lanto, you're talking crazy. I would suggest that you listen to your attorney. Okay? I'm going to adjourn this matter on his motion for 30 days.
Did you just say? Can you?
I'm going to send this to the assignment clerk, Mr. Lanto.
According to him, you have no jurisdiction over the matter, and apparently that's reason enough to ignore any instructions you might give. On top of that, he claims you're failing to provide him with liquefied crayons to eat, as if that somehow justifies his refusal to comply. It's almost laughable how he twists the situation to suit his whims. Despite all logic and procedure, he treats the courtroom as if it exists solely to cater to his demands. In the end, he's determined to disregard authority unless it comes with the incentives he decides are acceptable.
Because you like to talk and you think you know it all, and you don't listen. I'm going to adjourn your case for 30 days. I'm going to send the matter down to the assignment clerk. She'll send out a notice. Hopefully your attorney will have the discovery that he wants by then, and we can handle your case. Okay?
Well, have you kind of calmed down a little bit?
What did he say? No. You're all set.
It seems like you were getting angry. It seems like you were getting angry.
No, Mr. Lanto, you can leave the meeting. We'll see you in 30 days or so. Clerk will send you a notice.
Well, I just want the record to show I've asked these same questions in several courts, and nobody has said I'm talking.
Well, you know how Einstein defines insanity, doing the same thing over and over and expecting different results. In his case, it seems to mean asking the exact same questions repeatedly and somehow expecting a fresh set of incisors as the answer. It's almost as if he lives in a world where logic and reason don't apply. No matter how many times the questions are answered, he simply ignores the response and starts again. Watching him operate like this is both frustrating and, frankly, a little absurd.
He said I've been anything but reasonable in a courtroom.
Huh. That's amazing.
Huh, right.
You're talking like you know all about the law, and it doesn't make any sense to me.
Well, then let me ask a few questions for clarification.
You don't need to ask any questions. We'll deal with it in 30 days, Mr. Lanto.
Wait, we can't ask simple logical questions today?
Ask your attorney when you see him.
Like I said, I'd be willing to sign the guilty plea and just, be done with this if I just see the factual evidence of jurisdiction, number one. And
That's
then number
why we're
two.
asking for discovery.
Okay, and then the proof of jurisdiction is going to be in there? I'm asking a simple logical question. It's either yes or no. The proof is going to be in there or not. It's very simple. It's very logical, actually.
Well, let's see.
Mr. Lanto, I think maybe you ought to come into court in person next time, and your attorney will be here in person, and we can talk about it. So when you get that letter,
Well,
can I put on there that he's in person? I'm going to indicate to the assignment clerk that I want you here in person. You know where the courthouse is?
well, I feel like I'd be in danger if
Perhaps you should have thought about closing the gaps in your reasoning, or, more literally, in your mouth, before causing such a fuss. The only reason the judge is insisting that you appear in person is to manage your argumentative and disruptive behavior firsthand. He wants to see, up close, the patterns of contention you bring to the courtroom. No amount of written submissions can capture the chaos you create like your own presence does. Ultimately, this appearance isn't a favor. It's a necessary step to keep proceedings from devolving entirely.
In any danger, I'll assign a policeman to watch over you.
that's the
Chris,
scariest
would
thing
you
I could
watch
ever
over
hear.
him when he comes?
Absolutely.
That is the scariest thing I could ever hear. And that's coming from a very
Reasonable person, by whose standards, Webster's, Oxford, or even Colgate? I think it's safe to say that your grasp of the concept falls far short of any dictionary definition. In fact, I'd go so far as to suggest that you simply don't have the dental fortitude or mental capacity to attempt a redefinition. You're trying to twist a well-established standard into something it's never meant to be. At the end of the day, no matter how hard you try, you're outmatched by the simplicity and clarity of the term itself.
You, and you come into court, and we'll take care of business, okay?
So what does it mean to take care of business and I got to come in person and you're going to assign a police officer to me and then you said I'm talking crazy?
No, you got it
Did I
reversed.
just recall what was said on the...
Alright guys, that brings us to the end of today's video. As I mentioned at the start, this situation is one I find incredibly frustrating, and I have no doubt we'll be revisiting it again in about 30 days. I'll be back to react and break down whatever unfolds next, because this story is far from over. If you enjoyed the video, make sure to leave a like, and if it wasn't for you, feel free to hit dislike. Don't forget to drop a comment below, subscribe to the channel, turn on notifications, and I'll see you in the next video.